Hello and welcome. Today I want to talk about employee and labor relations. Employee relations, usually it's about employees and the employer or the managers and supervisors. So this is where we would talk about performance management, about training and development of employees, their career progress. And unfortunately, we would talk about layoffs, separations, terminations, and sometimes how do we manage the leave period when employees take some time off, either for good reasons such as family and medical reasons, or the fact that they would like to do internship or experience in that organization for a period of 5 to 6 months. How do we manage those leaves? On the other hand, labor relations in organizations about relations between the union and the company. So as we've seen over the last 80 to 100 years, there has been a decline in membership of unions. However, as we saw during 2008, 2009 financial meltdown, as well as the recent recession and inflation, we noticed that employees demand a lot more. So there has been sort of a resurgence of union membership, and unions have been more active in organizations. So labor relations is about the terms of employment between employees and the organizations. It's about the union representatives entering into a contract with the organization or management and having that collective bargaining agreement. It's about the grievance process, about the complaint procedures, about separation of employees, hiring of employees, and obviously developing of employees. So all of that is usually put in a contract between the labor representatives and the management of the organization. So it's important to understand both areas, employee relations, as well as labor relations in any organization. There are many factors that could influence employee relations, and that could include the agreements between union and the management of the organization, the local, state, and federal laws, the work conditions, the treatment of employees, and sometimes retaliations against them if they voice their opinions or concerns, and the overall culture of the organization as well. And usually all of these factors regarding employee relations tend to be written and documented in the organization's policies and procedures in the handbook. So the rules and expectations for employees and employers are often specifically documented. Some policies in employee handbook are not necessarily mandated, but they are usually part of the organization's culture and people run with them or go by them. The contents of the employee handbook should be accurate, enforced, and understood, though. The disclaimer is that the handbook is not necessarily always a contract between you and your employer. So we should emphasize that employment is at will in most organizations. And some companies actually try to encourage, emphasize, and clarify the organization's culture through the employee handbook and orientation programs for all of their employees on a regular basis. And there are actually many consultants and organizations such as the Society for Human Resource Management that do provide really good information in terms of what should be included in an employee handbook, how often they should be communicated to employees, how they should be emphasized, and the policies and procedures wording that are recommended usually by professionals would be encouraged through SHRM policies and recommendations. Some of the examples and types of organization policies that the Society for Human Resource Management or other experts would recommend would be to include the legally required information such as workers' compensation, family medical leave, and equal employment opportunity commission and non-discrimination procedures. We should include the code of conduct and the leave policy for employees in terms of how many sick days can they have, personal days, holidays. So some of those benefits that are offered and that differentiate your company from others could be included in the organization's policies. So there is no misunderstandings between employees and managers and their departments. Employee handbook policies and procedures should also include appearance, the dress code, the hygiene issues, the grooming standards, as well as social media policies. Like in terms of social media, companies do need to develop clear policies and communicate those policies in terms of what employees can and cannot do using the company equipment like computers and Wi-Fi during their work hours, as well as off the clock during their lunch hours or before they start work or after they finish work. So clarify these policies to all your employees in the handbook. So why do employees want to unionize? Well, usually when they are dissatisfied with the procedures or their immediate bosses or the managers in general within the organization. Sometimes people want to unionize because of ineffective working conditions and the fact that employees are often disengaged in the policies and procedures or rules that actually impact them on the job. And why is it that organizations oftentimes resist unionization? Well, because they're concerned about their profits. They cannot make the decisions all on their own. All decisions have to be agreed with the union representatives. Oftentimes there's decreased autonomy or an organization's ability to make decisions that impact their employees. Also, the worse the market conditions, the more likely that managers and employers are to choose union avoidance strategies rather than union labor cooperation strategies. Again, all organizations want to be independent. Managers want to make decisions more quickly as opposed to having to negotiate with union representatives. So managers often resist unionization in their organizations. But obviously, if employees are dissatisfied, eventually employees will want a vote or will want a say in whether they should be unionized or not. There are many union laws, such as Norris LaGuardia Act of 1932, which outlawed most court orders to stop union activities. There's the National Labor Relations or Wagner Act of 1935, which granted unions fundamental rights. And we also have the Labor Management Act of 1947, which sets restrictions to both parties, unions as well as management, in terms of unfair actions on the company's part or on the union's part. There's a requirement of 80-day advance notice before strikes can take place. And actually, the Labor Management Act of 1947 allowed the US president to stop strikes if it's a matter of national emergency or national security. In 2022, we noticed that the Biden administration's White House was involved in making sure that the railroad transportation workers did not actually go on strike. So they were able to avoid a strike over the last 24 hours before it was supposed to be initiated. So the president can actually intervene at times. And also we should be aware of the right to work state laws, where workers employed within the state are not required to join the union in order to obtain or keep their jobs. So what are the steps to union formation? Well, generally you form an organizing committee, you generate an issues program, you collect signatures. If less than 30% of the affected employees sign the cards, the process stops here and there's no voting. However, if you get more than 30% of the employees signing the card, then we move forward with filing an election petition. Then you conduct union election. Then the next step is to win the election. If the organizers lose a majority vote, the process stops here and no union forms. Then there's the elect union officers and finally negotiate a contract with the management of the organization. So this process is currently active in the United States. However, other countries and nations might have their own processes and steps for forming a union. So what is collective bargaining? Collective bargaining is the process of negotiating in good faith toward agreed terms on wages, on the hours that employees work, and the overall working conditions that impact employees on a day-to-day basis. The preparation for collective bargaining agreement requires both the employer and the union representatives to investigate some of the key issues that they want to negotiate, that their goals and the data to support their positions during the negotiation process. If the union representatives and the employer fails to reach an agreement, usually they resort to what is known as alternative dispute resolution, which does not involve litigation in a court of law. However, they can use mediation, fact finders, and arbitration processes to resolve their disagreements. Mediation is where an impartial third party facilitates the communication between the two parties. Fact finders are basically impartial third party members who make non-binding recommendations. Arbitration is where the impartial third party who listens to the facts of the case and decides the outcomes of the contract terms may actually be binding or non-binding depending on what the parties agree to. If they do not agree on any of the terms or conditions, usually we might have a strike in work stoppages. So a strike is a work stoppage as a result of the concerted refusal of employees to work. Lockout is withholding of employment during a labor dispute to enforce the terms of employment. Of course, if all else fails and you have a dispute or a grievance in the organization, usually employees tend to inform their immediate managers or bosses, and the boss usually asks you to fill out some sort of a grievance form. And then the supervisor and the union members tend to evaluate. If they agree that it is not a valid grievance or dispute, the process ends right there. On the other hand, if the supervisors and the union representatives do not agree, then the process needs to be resolved to the satisfaction of the employee. If the solution is found and the employee is happy, the process ends. However, if the grievance is not resolved to the satisfaction of the employee, usually it's escalated to the next level of hierarchy in the organization. If it continues to be unresolved, outside arbitrators might be called in to help in the process. If that doesn't work, then obviously the final step is litigation, which means a huge amount of time being wasted on or invested in the litigation process, both from the union side as well as from the employer side, where the lawyers would have to research, investigate, and argue each party's side. So both unions usually, as well as the employer side or management side, want to avoid litigation because it's costly and usually it's lose-lose. Unless you really believe you can win, you might invest in the process, but the outcome is obviously never guaranteed because many variables might influence the judgment of the court in terms of which side wins. And sometimes the employees actually want to decertify the union in their organizations. So the decertifying of unions requires at least 30% of the employees in the union to sign a petition to vote to decertify. So if 30% of the employees who are in union sign a petition to vote to decertify, then the process of decertifying unions begins. It's always best, though, to keep track of the number of disputes or grievances that are reported that go into mediation or litigation process and how long it takes, how much in terms of cost it takes to resolve these. So the more of these cases you keep track of, the more likely you can make a good case for HR analytics and training and interventions to avoid them in the future. As always, try to build a reputation for being an objective, analytic, and a rational professional in your field. And you can always do this by analyzing the numbers, by analyzing the facts, and by analyzing all of that data surrounding every situation to make evidence-based decisions. You can do it. Good luck.